Thank you, Adam. And hello, everyone. Good morning and happy summer. Summer's not just for kids, my friends. Hope you're having a good time. I want to second Adam. We love New York. The New York State Fair is starting next Wednesday and it runs through Labor Day, and it is really worth attending. And I say that as a native New Yorker originally. I've come to love that fair. So come on by. And the next thing I'd like to say is a special good morning to some folks who registered who I don't want to call you out too directly, but you work at a particular hospital that does particularly brilliant work. And so I'm saying a particular good morning to you and to everyone else who's on our seminar today. And I do wish to second Adam. We do have a Workers' Comp 202. It's a deeper dive, we call it. When you all registered, you submitted some questions ahead of time, which I very much appreciate. However, I can see that a lot of those questions are addressed directly in the 202. They tend to be complex questions, but we do handle them there. So I will handle them as well as I can during this one, the more introductory course.
I just want to hop in real quick, just to let everyone know, if you do have questions that, as Joe said, were probably more suited for the 202 session, we do have a recorded version of that webinar on our YouTube page. We'll give you the link later in the presentation today. So, but just want to make you aware that you can always check that out as well. Sorry, go ahead, Joe.
Good point, Adam. That was good. Thank you for doing that. Yes, but feel free to ask any question you wish. That's fine. We're here for you, okay? This is about education. So why don't we begin before there's ever an incident or before there's ever an accident? Let's talk about how do we create safer workplaces. Here is one idea that is quite common in industry, particularly in the more hazardous industries, like construction, for example, but this can be used anywhere. The Labor Management Safety Committee. We have some ideas on screen for how you may wish to form one of these committees. Essentially, my friends, it just involves people talking to each other in a collegial, constructive manner, wherein you're trying to identify the points and places and procedures in your workplace that could cause an accident or that are already causing incidents. Let's mitigate that, shall we? So you might want to do some safety inspections. You might want to check your equipment. You might want to check your procedures, and you may wish to just make sure you're training everyone and operating as safely as you can. Because we don't usually point this out, but it is very true. Everyone from the chief operating officer of a big company right down to the person who was just hired, you're all covered for workers' comp, and something could happen to any of us at any moment. So let's try and be as safe as we can. Here now, our system. Workers' compensation is a worker's right. It cannot be signed away. It cannot be negotiated away. You do not need to lose time from work to have a workers' comp claim. Okay, this is a no-fault insurance system. That means that somewhere in the mix here, there's an insurance payer. We will discuss that whole thing in a few minutes. And this is mandatory insurance coverage. Employers have to carry it, and workers don't directly contribute to the cost of this insurance. Immigration status is not a factor. This is a very common question, but it is really that simple. Your immigration status is not a factor in workers' comp in any way. Now, along with immigration, sometimes people arrive in the US speaking a language that's not English, because we have a lot of English, but we have a lot of other languages in the US too. Well, guess what? The board, our employer, has Language assistance services. Adam is showing you our web page right here. These are all the languages, I think there are 12 of them, where we already have documents created and available. And if a worker should need to speak another language, prefers some other language that's not listed there, don't worry about it. We'll get an interpreter on the phone if you call in, or if you have a hearing, we'll get an interpreter on the phone to interpret for you at no cost. It's a free service. The Workers' Compensation Board is the New York State government agency who administers and regulates and oversees the workers' comp system. It's mine and Adam's employer. There are about 1,000 of us all across the great state of New York in about 24 offices and hearing points. How do we do our job? Well, we're able to do our jobs because we receive the reports of injuries, the claim documents, the reports of payments. Every claim has a claim folder particular to that claim. So all of these documents are going to reside in that folder. And with that information, we can move the claims forward, and we can even hold hearings when it's necessary to adjudicate a claim. Not every claim has a hearing, but there definitely are circumstances when a hearing must occur, and we hold that hearing in front of one of our law judges. We will speak a little more about that in a moment, or actually towards the end. Oh, look at this. We already have a question. Are the offices open? No, I'm sorry. Our offices are not at the moment open to the public. At the moment, they haven't been open during the course of the whole pandemic, but they will reopen, and you will have plenty of notice when that's going to happen. But sorry, no, they're not open to the public right now. The Advocate for Injured Workers. Well, that's me, actually. And I have an office of people, the Office of the Advocate for Injured Workers. I am technically an ombudsman. An ombudsman is someone who cares about the health and the sanctity of the workers' comp system. The people in my office and I, to accomplish that, we will help workers with the more difficult and more complex claims. We are also involved at the start of any fatality claims, because there is a fatality benefit in this system. And I work directly with the 9/11 community, and we're going to show you now some resources for World Trade Center responders. Here you go. Across from left to right. You know there's a workers' comp benefit. So anyone who responded to World Trade Center, if you were paid to respond, there's a workers' comp benefit available. But there are also some other benefits that we like to call out to you, such as, you could see on the far right, it says World Trade Center Volunteer Fund. Well, if you responded as a volunteer, you can file a comp claim. In the center, the September 11 Victim Compensation Fund, that is a federal program. That is administered by the Federal Department of Justice. And so if you were impacted in that area, there is a specific area, you can file a claim with the Victim Compensation Fund. If you haven't done that yet, I would encourage you to check that out. Then finally, on the far left, WTC Health Program. Federal government is paying for health programs all across the state, and frankly, all across the country as well. There's a national network to help people who have become sick as a result of the World Trade Center disaster. I would encourage you to check into that as well. I will be in the city on September 9, September 10 with this wonderful organization called Voices of Resilience. They used to be known as Voices of September 11. They have an annual symposium. It's one of the most important things I do all year. So if you were impacted by the events at the World Trade Center, I would encourage you to check out Voices of Resilience to see if the symposium is for you. And finally, in order to accomplish all of these tasks, I report directly to the chair of the board, to the head of the workers' comp board. That's typical for an ombudsman. All right, new topic. Who pays your workers' comp claim? Well, if you think it's the workers' comp board, it's not, except in one particular small instance that we'll get to. I mentioned that there's probably an insurance payer in the mix because employers have to carry insurance. Well, employers have two options. First option, they can buy an insurance policy. There are about 260 different insurance companies who write workers' comp insurance in New York. The largest is the New York State Insurance Fund, NYSIF, NYSIF, or SIF, or the fund. I'm only calling them out because we are not them, okay? People tend to confuse us a little bit early on. So just letting you know, there is an insurer known as the New York State Insurance Fund, and there's also a New York State Workers' Comp Board. So an employer can buy a policy, but an employer can also self-insure. That means that the employer has the financial capability to pay workers' comp claims out of its own funds. So that's going to break down in two avenues. The first, public employers, government entities, towns, cities, school districts, they can and frequently do self-insure. The other route is private employers. Well, private employers can self-insure if they get the consent of the workers' comp board and if they demonstrate that they truly do have this financial capability to handle these claims. There's going to be letters of credit or collateral or that sort of thing to make sure everything works properly, and it does work properly. But here's the important point. Self-insured employers almost always hire a claim administrator to process and pay the claims. Now that's fine, and those claim administrators are licensed by this board, but I'm calling this out to let you know that if you're a worker and there's a claim, you are almost certainly not going to be dealing with your direct employer. You're definitely not going to be dealing with your manager, your supervisor, your HR, because they're probably not going to be handling the claim themselves. There's either an insurance company or a claim administrator who's actually handling the claim. Finally, our last bullet on screen, there is one instance where the board will advance payments, and that's when the employer should have been carrying insurance but did not. That's a pretty big problem. That employer has a pretty big problem. There are probably going to be significant penalties, and the employer is ultimately going to have to pay the money back to us out of his or her or their own funds. But the point here is that we have a unit called the Uninsured Employers Fund. They will advance the payments. So the worker will be held harmless. Therefore, if you're a worker, you get hurt, don't worry so much about whether there's insurance in place or not. Just file your claim, let us know about it, and we will sort it out. Who needs coverage? Who needs this coverage? Well, businesses with employees, they need the coverage. When we say a business, we're speaking of a for-profit entity. You're for profit and you have employees, you need the coverage. Even if you have one part-time employee, even if you have one part-time employee who's your niece, you still need the coverage. Most not-for-profits are also required to have this coverage. Question's going to be now, I'm talking about having employees. Who's an employee? All right, let's look at this for a moment, please. Anyone who's providing service to a for-profit business can be determined an employee of that business by the New York State Workers' Compensation Board. By the board. So if your friend says you're not an employee, if your boss says you're not an employee, it's great. People can say anything they want. But if there's an incident, file the claim, and we make the determination. Same thing on the not-for-profit side. There are some limited exceptions. Like if you have a 501c3 and you have clergy or teachers in a 501c3, then the organization does not have to include them on comp. But if they have a bunch of people doing manual labor, they need a policy, and they certainly could include those people on the policy. That's fine. It's always okay if you buy a policy and include extra people. That's always okay. It's legal. It's lawful. It might be smart because if you're a business owner and you've excluded yourself from the policy to save a few dollars, I'm going to encourage you to really think long and hard about that and put on the one side of the ledger how much you're really saving, and on the other side of the ledger, what are you really giving up? Because I'm not going to tell you the sad story, but we here in this building know a very sad story where a business owner, we wish, had included himself on the policy. Does a person have to insure themselves? No. If you're a solo practitioner, no, you don't have to insure yourself. If you're a solo practitioner, you do not have to buy a policy to cover yourself. You might wish to, but you don't have to. And at this point, Adam's looking right at me. He knows what I'm going to say. We have an advocate for business who does a similar webinar. So I'm going to encourage you, if you have these types of questions, check the webinar schedule, check the advocate for business schedule. They really go into detail on these type of questions. The only other thing I want to point out is this coverage requirement I'm talking about can potentially include internet businesses. If you think that, okay, so I get my assignments from an internet business, i.e., or I should say, e.g., ride sharing maybe. If you think that you get your assignments through something internet-based, therefore you're an independent contractor, well, not so fast. You might not be. Just because somebody says you are doesn't mean you really are. You can go ahead and file that claim and let us sort it out, because you might be an employee for workers' comp purposes, but not for tax purposes, because we all use a different law to make these determinations. New topic. Now we're getting into it. What do you do if there's an injury? What do you do if there's an incident? Well, this is what workers ought to do, and I have some tips in here for employers too. Here we go. Number one, there's an incident. Go get necessary medical care as soon as you can. If there's an incident and it's an emergent situation, the employer does not have the right to tell you where to get that care. The employer does not have the right to tell you where to get that care. They can drive you to an urgent care. That's just being a good Samaritan. Love it. But the worker can pick out where the worker wishes to go. And if the worker wishes to have a private examination, the worker does not have to have anyone else in the exam room. I know it sounds funny that I'm saying that, but I keep running into these incidents, so I feel like I ought to say that. Next, you're the worker. Tell your employer in writing that you got injured. This is very important for several reasons. Number one, it's the right thing to do. Number two, maybe the employer could mitigate that situation so no one else gets hurt. Number three, it's required because it's a form of notice. It's one of the notice steps. Oh, here's what I wanted to say. I'm sorry. When you do this, I'm saying do it in writing. It's 2023, so we have all these options. You can hand a document over. You can send an email. Those are the things I recommend. I personally love the email idea because it has an audit trail. People like to text, okay? A text is legally acceptable, but I wouldn't do it because let's say you need to show that text in 11 months. Do you think you're going to find it? Or even better, do you realize that your cell phone has settings that even determine how long it keeps a text for? The default setting on iPhones is 30 days, my friends. So that's why I'm saying don't text if you can avoid it. Next thing, you're doing this because the employer must tell the insurer. The insurer must tell the board. Now we have notice. That's why you're doing this. However, you may also file an employee claim form. It's called the C3. So if you ever hear anybody talking about a C3, this is what we're talking about. We're showing you the online submission form. You can do this on paper if you like. You can download and print the paper and mail that into us. That's fine. But if you can do this one online, can you click through the tabs? If you can do this one online, it is so much easier and so much cleaner. Okay, we would have to complete it to go to the next tab. I just wanted to show you just how brief this really is and just how easy it probably really is. So that's what I'm recommending you do. File that C3. It's not mandatory, but it's very helpful because then we know for sure we have the notice. And you all should continue getting your necessary treatment. And remember, workers have 2 years after an incident to file a C3. So your time window is 2 years after the incident. Now, a word from Matt.
Thanks, Joe. You'll see a scenario on your screen here. Joe and I want to get your opinion. You're gonna see a poll come up. You can put your answer right in the poll. So we have Kadir. Kadir is not an American citizen, and he is in the United States on a work visa. Kadir works 40 hours a week on site at a software company at an assigned desk using that company's equipment on tasks the company assigns him. He does work his 8 hours per day, though his start and end times do vary. He is paid on a 1099, so the software firm considers him to be an independent contractor. One day, Kadir is inattentive and he drops a computer server. It injures his left leg. The employer calls an ambulance that takes Kadir to the hospital. So knowing all of this, do you think Kadir should file a workers' comp claim? Poll is now open on your screen if you want to just put in your answers, yes or no. Do you think Kadir should file a workers' comp claim in this instance? We're going to give people a few seconds here to put their answers in, though we do have answers coming in now.
I love when they come in.
Yeah, we have actually got some good participation here. Right now, the majority of you say yes, Kadir should file a workers' compensation claim. We do have a couple folks who do not think he should. Joe, what is the correct answer?
I'm sorry, I'm just enthralled at watching the numbers come in. Yes, we think Kadir should file a workers' comp claim. Excuse me. There was an incident and Kadir got hurt. So why wouldn't he file a workers' comp claim? It happened right in the workplace. Then we set the question up so that we could test a few of so we could assess some learning here, as in he's not an American citizen, visa, so what? Immigration status is not a factor, remember? And then software firm considers him an independent contractor. Oh, that's great, but is he an employee for comp purposes? Well, if he's there 8 hours a day and he uses their equipment on their desk, on their and doing their tasks, there's a strong possibility that he could be considered an employee. And then finally, the last bullet, just to reinforce, the employer called an ambulance. If the employer calls an ambulance for you, the employer had notice, okay? They might dispute that, but if it comes in front of a judge, there's a high probability it'll be found that the employer had notice because they called an ambulance. They clearly knew about it. We're now going to speak about the benefits. We're going to speak about the medical benefit, and the lost wage benefit, and then the fatality benefit. Medical benefits first, because our health is the most important thing. If we don't have it, we don't have anything. The medical care, the health care, because there's medical, podiatric, psychological, chiropractic, all those types of care are available to the worker for the work-related injury or illness for life. Once the claim's established, it's a lifetime benefit. I'm sorry to belabor such an obvious point, but I have to say it again. It is a lifetime benefit. Claims do not close unless a special contract known as a Section 32 is struck. So claims don't close. It's a lifetime benefit. And all the medical expenses are covered. Testing and inpatient, outpatient surgery, physical therapy, durable medical equipment. Transportation costs to and from healthcare appointments are reimbursable. That means if you're a worker and you're going to and fro to get your healthcare, you can file Form C-257, Form C-257, and you can be reimbursed for your travel costs. That's an important thing. And that also pertains to independent medical exams, which we'll speak about in a moment. Here's a best practice for medical care. I'm going to start at the bottom. I'm sure any healthcare provider is going to cheer when I say this. People, when you arrive at your appointments, bring your board case number. It's going to have 8 characters. It very possibly will start with the letter G for glorious, and then I'll have 7 numbers. You should also bring the name of the insurance company, and you should bring the case number that the insurance company assigned. If you do this, then your healthcare providers can actually file and bill and get paid for their services, which we're very much in favor of. Also, if you are on temporary, or if you're in temporary status, temporary total, temporary partial, you're going to have to see that provider or doctor every 90 days, okay? Because we need to know how disabled you are. The doctor is going to say how disabled you are. That is called a degree of disability. Understand it, because if you're 100% disabled, you would qualify for 100% of the available benefit for you. If you're 50% disabled, you're going to qualify for 50% of the available benefit for you. And then finally, if you don't do this, your benefits could stop, because we need that degree of disability every 90 days. Someone is asking about workers' comp providers. Well, the good news is more providers are in this system every month than the previous month. So we are enrolling providers more every month than last month. So we are net positive every single month, and the number of providers just keeps increasing. We want the best providers. We want to make it easier for providers. But yes, we are enrolling more providers every month than the previous month. You can see the charts on the website. And if a provider has a particular issue, they should be contacting the medical director's office. You can start in my office too if you like, because I'll help you as I can as well. If a worker has a problem with a provider, an authorized provider, they should be contacting the medical director's office or my office, and we will speak with that provider. Sometimes it's just a matter of a little education. Now, independent medical exams. This is a facet of the system wherein an insurance payer may ask a worker to attend what's known as an independent medical exam, which means that the worker is going to see a physician. It's almost always a physician. They're going to see a physician that's being paid for by the insurer to give an opinion on some element of the claim or the worker's health. So here are the things workers ought to know about that. Number one, there's no doctor-patient relationship. There's no expectation of confidentiality at this appointment, and this doctor is not going to be providing treatment recommendations or any treatment at all. Number two, you certainly may bring a witness. Sometimes it's a good idea to bring a second party to a complex medical exam, but you certainly may bring a witness to an independent medical exam. You certainly may record it. Maybe your witness wants to record it. Maybe on a cell phone, a smartphone. You don't need to bring in a big old camera and lights anymore. You want to capture the video and audio? Go on ahead. No one can tell you no. Now, the reason you're doing this is because there is going to be a report generated, and you're going to get a copy of it. If you have a lawyer, your lawyer will get a copy of it. You really need to read it, and you really need to be able to pinpoint where the findings are coming from. And you can double check that with your video audio recording. If it turns out that you're seeing findings in the report that you can't identify where they're coming from, well, if you have a lawyer, tell your lawyer, but make sure I hear about it, because I accept complaints as ombudsman. Now we're back to the whole ombudsman thing. I accept complaints about IME conduct. Now, when we say conduct, we are talking about these discrepancies in reports, but we're also talking about were you examined in a professional medical facility? Were you treated by the staff in the way that one would expect one to be treated at a medical appointment? Did you get examined in the waiting room because your wheelchair didn't fit in the exam room? That's happened. Okay, so if this happens, if something is amiss, you can make the complaint to my office. I will review it, and I will go to what's known as the practice committee. And we definitely do take action on these things because we license the IME companies. And yes, it has happened that an IME company actually lost its license because it was not performing as it ought to have been. Finally, you're a worker, you have to go to an IME. You can, and I don't know why you wouldn't, claim travel reimbursement to and from that exam. New topic, the lost wage benefit, the cash benefit. This is technically known as indemnity. Here's how it works. The 100% disabled maximum benefit is going to be 2/3, 66.666667% of the worker's average weekly wage. Here's what happens. Let's say you had an incident on June 1st. That's your date of accident, June 1st, date of incident. The insurer and the board, we're going to look back 52 weeks from June 1st, and we need to know all your compensation from all of your jobs. Okay? Because if you have two jobs, that's called concurrent employment. You have two jobs. If you're 100% disabled from one, you're 100% disabled from the other one. So we need to know all your compensation. And I'm saying this to the entire community, which does include the people who fill out the C-240s. We're talking all compensation. We're talking bonuses. We're talking overtime. We're talking allowances for uniforms. We're talking all compensation. Then you have to look at what's the maximum benefit available. Well, as of July 1st, it is now $1145.43 per week. That adjusts every July the 1st. All benefits are temporary unless you have a permanent injury. Okay, remember I was talking earlier about you have to go see the doctor every 90 days if you're temporary partial or temporary total? This is what I'm talking about. Everyone's considered temporary unless they have a permanent injury. And we won't know if you're permanent until your body has enough time to heal, which generally speaking, 12, 18, 24 months post-injury, okay? It's unique to every person, and sometimes you have to go to an IME appointment because the insurer wants to know, is this person totally healed or as well as they're ever going to get? There's also a benefit if you should lose. I'm sorry, I want to back up. I was just talking about temporary benefits. There are also permanent benefits, and they come in two varieties: permanent partial, permanent total. Temporary partial, temporary total, permanent partial, permanent total. So if you have a permanent total incident, or it's known as permanent total disability, you can't ever work again. A judge is going to classify you as permanent total, and you're going to get the maximum benefit you qualify for the rest of your life. If you are permanently partially disabled, you're going to get between 4 and 10 years of benefits. It's going to depend on how injured you are. We go through this in great detail in the Workers' Comp 202, by the way. There are also payments for the loss of use of a limb. So we're talking arms, hands, fingers, legs, feet, and toes. Each one has its own amount of benefit allocated for loss of use. So you can lose 5% of the use of your arm, or you can lose 95% of it. There's a benefit. Obviously, the 95% loss of use is a much bigger benefit than the 5%. But just be aware of this. And if you're a worker who got hurt 7 years ago and you hurt a leg or an arm or a hand, and you don't feel like you ever came back 100%, go to the doctor, get an exam, see if you have lost use and you never claimed it, there might be a benefit. Also, please note where you're working when you file that C3. It's a very simple thing, but if you can get an address where you got injured, please note it. It's very helpful. Now, we're talking about getting these payments. All right. How are you getting these payments? Please don't tell me you're still getting paper checks. Okay, I'm going to be brief. I make a bigger plea in the 202, but my friends, if you're getting paid every 2 weeks and you can have a bank account, please consider using direct deposit. Thank you. Now, the other thing is, let's say that you're working and you get paid in cash. Cash is legal tender. It's okay. People who get paid in cash can file comp claims. I'm just going to encourage you to keep some records, okay? Get yourself a notebook and write down who paid me, how much, on what day, for what service. Because if you file a comp claim, we're going to need to know how much money you were earning. If you have a contemporaneous record, that's going to be hugely important and hugely helpful. All right, question came in, Adam. Do you want to read that question, the bottom question, so I can take a drink of water?
Sure. If a provider writes a doctor's note taking an employee out of work, would that employee be considered 100% disabled?
Okay. If you're taken out of work, I don't know what that means. That's a pretty nebulous term, and I'm terribly sorry. I'm not being difficult with you. We live in the world of percentages. So maybe that's 100% disabled, but it's so much better if the doctor uses language like 50% disabled, 75%, 100% disabled. So if you're a provider and you don't believe this person should be working because the person is 100% disabled from work, if you use the percentage, it's so much cleaner. Why don't you do the next one?
Sure. For IMEs that we were just speaking about, is the travel and mileage reimbursement guaranteed regardless of whether the claim is accepted or not?
No. Your claim does have to be established. Okay, please notice that I'm changing your terminology a little bit. I don't care if it's accepted or not. Well, actually, I do. If it's accepted, it's going to be established. If it's not accepted, you could still litigate it and establish it. So the key, Adam, is that once the claim's established, yes, that reimbursement is payable. All right, we're going to turn back now to the final benefit I wish to discuss here, the fatality benefit, because there is one. We're showing you right here a publication that we made that really does explain all this in great detail. But the important thing to remember is there is a very, very important and necessary fatality benefit if a worker should perish due to employment. Okay? It's not just for an instance where a worker is killed instantly on a job site. Okay? The benefit is payable if the worker dies due to the employment. Now, here are the benefits. There's the funeral and memorial expense. This is geographically focused. So, in the classic New York City metro region, New York City, Long Island, Westchester, Rockland, up to $12,500 is reimbursable. On the rest of the state, it's $10,500. Now, there is a weekly benefit available to the surviving family, and it's calculated, the dollar amount is calculated in the same manner as the lost wage benefit. It's just that who's going to receive the benefit? Well, first we look for a lawfully wed spouse. Lawfully wed spouse. Gender, not a factor. Then we look for children up to either 18 years of age or 23 if they're enrolled in higher ed, accredited. And then we're looking for disabled or blind dependents of the deceased. So we look in that order, and those parties would share the one benefit. The spouse and the disabled or blind dependents, they can have it for life, except if the spouse gets remarried. If the spouse remarries, the spouse gets 2 years of benefits in one check, finished. If it's a spouse and a child, they're sharing it and the child ages out, the rest of the benefit goes to the spouse. If there are no survivors of these types, the parents of the deceased worker may receive $50,000. These maximums have been in the law for a long time, by the way. If any of us have any influence or interest in these types of matters, the law spells out the $50,000, and that's been the amount for a very long time. If there's no family, $50,000 is payable to the estate. So we will be dealing with an executor, executrix. If you're a family member and, a cousin, an uncle, someone you're extremely close to, you love the world out of this person, but I did not name you already, you have to deal with the estate. Finally, we mentioned Kids Chance. Kids Chance is a national nonprofit that does provide scholarships to the children of workers who've been fatally or seriously injured. We're showing you the webpage here, kcnewyork.org. We're not affiliated with Kids Chance, but Kids Chance is a national organization with a chapter in every state, and nationally, the different workers' comp systems, we do mention Kids Chance because they are obviously trying to do such important work, and it's August. So if you have a kid going to college and you're not sure how to pay for it yet, or maybe you want to give back financial aid because you're going to get a scholarship, I'm really encouraging you to go to that website and get yourself an application, because I know for a fact they're taking apps right now and they want your application. COVID-19. One of our attendees asked a question about COVID already. I didn't ignore your question. I was just saving it for here. COVID-19 is an infectious disease. Infectious diseases are payable in the workers' comp system. Not only COVID-19, something like Lyme disease. Okay, it's August. People are bumping into ticks right now. So, what's unique about COVID-19? Well, there are just these couple of elements I'd like everyone to know. Number one, medical reports are always necessary. They're going to be key in this instance. If you have a positive PCR test, you need to file it. Please file your PCR test. If you never had a PCR test, it is possible for a doctor to give a diagnosis of COVID by virtue of exam. That will work too. And then the question is going to be, where did you get the COVID? Now, I know someone is keying a question right now into the chat box, Adam, and they're saying, how do I prove that I got COVID on the job when you can't see it? Here's how. What you're doing is you're really discussing this with your provider, your doctor, and you're going to give the doctor the details of your workplace. Okay? Public contact, anybody wearing masks any longer? Was there COVID-19 in your workplace? Like, did your 5 coworkers all have COVID and then you got COVID the next day? You need to tell your doctor this because this is a comp claim and everything turns on the medical. So, if your doctor thinks that you got COVID at work, if it's reasonable, was it prevalent? Because what we're really talking about here is the likelihood you got it at work. Nobody's expecting you to point to an instant in time where somebody sneezed and you breathed it and you got COVID. Nobody's expecting that. What we're doing is we consider the likelihood, and these details are going to come in on the medical reports. So there is what we now call long COVID. So remember I said that the medical benefit is a lifetime benefit? Okay, if you're struggling with long COVID, did you file a claim because you got it at work? That's a question. Did you think you got it at work? If yes, you need to file a claim because this is a lifetime benefit from medical care. And we do have a fact sheet available. We do have a short video available. And I would encourage everyone to please take a look at it because we have this whole page here about COVID-19 info. We have news and you can file a claim. You can find a provider. If you're looking for a provider, click that. That'll get you there. We have a page for that, but we give you multiple clicks into it, multiple places to get it. So we have tons of COVID information available to you. Adam has something he'd like to discuss with you about COVID as well.
I would. We have another scenario for you, and Joe and I would like to get your thoughts. So now we have Liz. And Liz worked at a big box store in the seasonal department during the holidays where she dealt with the public. One day, Liz felt ill and she called in sick to work. She took a PCR test, which turned out to be COVID positive. Liz did receive her paid sick leave for the 2 weeks of work that she missed. And during the time she was at work, she was very vigilant about following COVID-19 protocols. She wore masks, she social distanced. And during that time, several of Liz's coworkers also had COVID-19. So, knowing this, do you think Liz should file a claim for COVID-19 exposure at work? And you will see a poll has just popped up and opened up, so we want to get your answers there. Again, just simple yes or no. Do you think Liz should file a claim for COVID-19 exposure at work? Again, we're going to give you a couple seconds here to get your answers in. We do have answers coming in now. And Joe, it looks like, again, the majority of people do think Liz should file a claim. We have a few no's, a little more no's than last time here with Kadir. Some people feel differently about Liz, apparently. What is the correct answer? Should Liz file a claim for COVID-19?
We think Liz ought to file a claim, and we would like to give you the additional piece of info, which I neglected to say earlier, which is there's no penalty, my friends, if you file a claim and it's not established ultimately. There's no penalty for that as long as you're truthful. But Yeah, on this one, I think that some people might be saying, no, don't file a claim because Liz got paid sick leave, which is a whole different other benefit outside the comp system. Okay, so maybe if she got paid sick leave, she's not going to get any additional money, but we want to see her get that lifetime medical care for sure. We have a question that came in. You know what? I'm going to save some of these questions. Okay. So if you just gave us a question, even if it's right about this, I'm going to save those because I need to get through the rest of this and then we'll do your questions. There are some penalties for late payment. Benefits have to begin within 18 days of incident or 10 days from notice. Remember, we said you need to tell your employer who tells your insurer. That's called notice. That's a form of notice. You need to do that. The benefits need to start within those thresholds. That is why you need to tell your doctors when you go to the exam if this happened at work, and anything the providers can do to get those bills and reports filed ASAP. That's going to be very helpful. Let's say there's hearing. There's going to be a decision. The decision is going to have a filing date. The money has to be released within 10 days of that filing date, or there could be a penalty payable. Someone asked this before the session, Adam. My check is always late from my insurance company. Well, in fact, in the law, if you're getting a payment every 2 weeks, it's not eligible for a penalty until it's 25 days late. That's why I urge you to go on direct deposit if you can, because those problems seem to vanish once we get out of paper checks and into direct deposit. You're a worker, you have a comp claim, you have a few responsibilities. Try to get back to work as soon as you're capable. Talk to your employer about transitional duty, or what's known as light duty. I'm speaking to workers. I'm especially speaking to employers and insurers right now. The insurers can talk to their policyholders about this. You're an employer. Come on. Someone is healing and can make some contribution to your workplace. Why do you want them out on 25% disability rate? Bring them back. Give them something to do that they can do within their restrictions. You get them back. They're healthier. They're going to have a better outcome probably because all the studies show this. You get some productivity out of them. And guess what? You're not paying the indemnity anymore. It's not hitting your premium experience anymore. You're helping yourself too. If the board sends you an inquiry, would you please respond to it if the board does? And make sure we all know where you are, your mailing address, please. Finally, that bottom bullet, that is so important. If you're a worker, remember I talked about a claim folder and all your documents are in there? We call it e-case. Guess what? You can register for e-case access. If you do that, you can see every document in your folder. You'll see what we see. It's the best thing you can do probably to help yourself. So urge you to sign up for that. There might be a hearing in your claim. Here's what happens at a hearing. There's a law judge, there's you and your lawyer if you have one, and there's the insurance company's attorney. So you certainly can hire an attorney if you're an injured worker, and there are instances where, oh my gosh, that's probably the smartest thing you can do because you're going to be facing an attorney on the other side. There's going to be a law judge who's going to make the findings of facts. We might have witnesses. There might be depositions. There might be testimony. Our hearings are usually very brief, comparatively speaking, as in many hearings are scheduled for 8 minutes, and they only go 8 minutes or less because there's really not more than 8 minutes worth of business to do. If we schedule you for 45-minute hearing or an hour hearing, that's pretty much the limit of how long our hearings go. We also do not use the formal rules of evidence and procedure that you see in a courtroom or on television because we don't actually operate courts. This is administrative law. And You're not going to come into our office right now. You'll have a virtual hearing. This is a very, very good thing, though. This allowed us to keep doing hearings during the pandemic when some other systems were closed. So we use the virtual hearing software, which is essentially a teleconference. If you have a cell phone with a camera or a tablet or a computer with a camera, you can participate that way. You're going to get a hearing notice. The hearing notice will say to do the virtual hearing, either use your virtual hearing app, because we do have an app. You can get it from Google or Apple. Promise, it works. Or you can use the information that's on the hearing notice to come into your virtual hearing. Or if you can't make that happen, you can participate by telephone. You just need to get in contact with us by the morning of the hearing. I'm talking like 8:30, 8:40, 8:50 a.m. Get in touch with us then. Hearings start at 9, so that we can put your phone number in there and tell the judge to call you, because the judge calls you. The judge calls you. I think we're near the end here.
Yeah.
Here are our social media platforms. The YouTube, it's okay. The YouTube channel that we have, I would suggest take a look at that, because if you're looking for a video of this training, guess what? We have about 37 of them there, because we've done this, I think, the last 37, 38 months in a row. So they're all there, along with all of our other videos. Don't go anywhere, though, because we're going to do your questions now, and we'll leave my contact information up.
Yes, thank you, Joe. We do have some questions that came in during the presentation that Joe was not able to get to. So we're going to take a brief moment to review those. If you do have questions, though, feel free to continue putting them in the chat box. We will get to whatever we can. But again, we're going to take a brief moment to review questions that have already come in, and we will be back with you shortly. Thank you. All right, we are going to start with this question. How does the board monitor and regulate private insurance carriers that routinely try to deny medical payments to injured workers?
Okay. I need to change it just a little bit to match what really happens. Injured workers don't get medical payments. The providers get the payments. So I'm going to read this as, what does the board do to monitor and regulate insurance companies and paying for medical services? Well, we have this entire system set up so that if there is a dispute about paying the provider, either the insurer must file documents, because they must, or they have to file the documents, and the providers can also dispute the payments. So we do have an entire system, and we do have an entire unit called disputed medical bills. So yes, we have procedures in place to address those instances.
Can workers' comp be eligible for remote workers? So for example, if an employee is working from home and they suffer a carpal tunnel.
Of course. Yes, remote workers are covered for workers' compensation benefits as well. Okay, someone put in a comment about losing his or her husband on September 11. Okay, why don't you get in touch with our office? We should probably be talking to you. So to the person, I'm terribly sorry that happened. Please get in touch with my office directly.
All right, we have a question here. What if the insurance carrier, who's a third partner or a scheduler, withholds pertinent medical information from an IME physician and has them write false statements in an addendum that wouldn't have been written had they not been withheld in the medical findings?
Okay, I see what's going on in that question. I can clarify it for the rest of us. The writer of the question thinks that the independent medical examiner did not get information that was germane and pertinent and important to the exam, okay, you, to this writer, send an email to that email address on screen right now and give us your case number, your WCV case number, and please be specific with your details, because we will consider this something that needs to be researched and possibly as a complaint that needs to get referred for consideration or review, further review. It is possible, I have to say this in fairness, it is definitely possible that you don't quite have the relevant picture here unless you are a doctor, but it's also distinctly possible that you're bringing something forward that does need review. So either way, write it up and send it.
Are there payments for an injured woman who suffers a miscarriage due to a work-related injury?
That, I'm sorry, I've never had a miscarriage question before, but if this is a work-related incident, it has to be work-related. But yeah, if you got injured, you got injured. If you had a miscarriage as a result, I don't know that there's any additional benefit for the miscarriage, but yes, a work-related incident is payable in workers' comp.
All right, so if a doctor puts an injured worker at 75% temporary disabled, and then asks the injured worker to work under modified conditions at a job. However, the employer does not have opportunities for a modified job for that injured worker. So under these circumstances, should the injured worker be paid with 100% temporary disability, even though the doctor claimed them to only be 75% temporarily disabled?
If the treating doctor says 75% temporary disability, then the benefit rate is going to be 75%, unless by some quirk, the worker had an independent medical exam who gave him 100%, who gave him a higher degree of disability. That would be very unusual. It's happened, but it's very unusual. So if the highest degree of disability you got was 75%, you're going to get the 75% rate.
Is there an official end date for COVID-19 and workers' comp?
Not in workers' comp, no. COVID-19 is an infectious disease. Infectious diseases are payable in our system.
What is the best way to file a claim that doesn't have a specific injury date, but is from an injury caused due to long-term exposure due to job conditions, such as repetitive motion?
Yes. Okay. Now, please don't consider this legal advice, but you can file that claim and you can leave the field blank, or you can use maybe the date you became aware that this injury is due to a work-related situation, or you can call a lawyer and maybe think about retaining an attorney and doing what the attorney says. So those are all different options. Don't consider them advice, please, because they're not. There are just several ways to do it, including not having a date at all. So don't get hung up on the date. File the claim. Okay, we back to COVID. We have a very active participant who I'm delighted to see asking about insurance companies controverting COVID claims. Yes, that does happen. And those claims do go into hearings. I'm going to encourage this particular attendee. Why don't you send an email to me over at that address? I think you and I should probably have a person-to-person conversation, because I think we have a lot to talk about. You know, and I say that in the most collegial and friendly manner I can, because I mean it. I think we have a lot to talk about.
Comp is only a monetary benefit and does not automatically excuse an absence. Is this valid?
Okay, the interesting element here is the way the question is framed, which very possibly might come out of an employee handbook. So, yes, if the employer does not wish to automatically excuse absences due to a work-related injury, the employer actually is within its legal rights. An employer may not terminate you for filing a claim. However, there are other things that sometimes happen that do, and of course, there are other things that can happen. So I would encourage any employer to please have a little consideration for someone who got hurt on the job. But what I said is the situation. And if you are a worker and you do believe you were terminated because you filed a claim, you may pursue a discrimination claim with us. It's actually discrimination retaliation. And we have a form on the website called the DC 120. D is in discrimination, C is in claim, 120. And you can file that. And our law judges will hold a hearing, and they do have the authority to award you back pay, and they do have the authority to restore you to employment.
All right. I do see a couple questions here asking about a copy of this presentation. Joe had mentioned our YouTube page. We do have a recorded version of this presentation on our YouTube page. It will be updated as needed. When that updated version is posted on our page, we will send an email out. So make sure you're signed up for email notifications for that. Getting back to our questions here, how long do you have to submit a claim for COVID-19, Joe?
The same length of time you have to submit any claim, 2 years from incident. Someone is asking us, Adam, about FDA-approved treatments for COVID. I'm sorry, you have exceeded my expertise with that. So the rule on pharmaceuticals, let's just go back to the rule on pharmaceuticals. Is it being prescribed and used in the approved manner? And if not, possibly, let's say the physician wants to get a variance to use a drug in a particular manner, they would follow the variance process. But I'm looking at an extremely detailed question that I think Dr. Tachi might be able to answer, but I don't know who else can answer. So you're going to have to pose that maybe in the medical director's office.
Yeah, I'm going to post the MDO email address in the chat for you. You can email them for that question. And also on the topic of COVID-19, and I just mentioned YouTube, there is also a recorded version of a specifically workers' comp and COVID-19 related webinar we've been hosting. So please check that out as well. Just want to plug that in while we're on the subject of COVID. On the example for immigration, non-citizen workers who had a work visa, would workers' compensation coverage apply to a worker without a work visa?
Yes. Remember I said immigration status is not a factor? This is one of those precious moments in the comp system where you can make a categorical statement, a sweeping statement. Immigration status is not a factor, period.
Does an employer have to give you light duty work, or can they decline even if the provider recommends it?
The employer may decline. The employer may decline to give you light duty as an injured worker, even if the provider recommends it. The employer is making a business decision. I would just hope that for business reasons, for humanitarian reasons, they give you the light duty and get you back. But yes, they do have the right to decline if for some reason they wish.
Are benefits only for workers in New York, or do they change from state to state?
Then what a great question that is. Sometimes I say this casually. Every state and the District of Columbia is a jurisdiction. So there are actually 51 jurisdictions in this country with 51 different systems, 51 different sets of rules.
If you use your personal phone for any workers' compensation related matter, Does your phone become discoverable, and have you seen this change in the course of a claim?
I don't know. That's an intense legal question. I don't know. And I don't know why you're necessarily getting too hung up on that, because if it's discoverable, it's got to be coming from one of our judges. It has to be coming from one of our judges, and they might just ask you for a record, or I don't know.
All right.
You need an attorney. You need a private retained attorney to answer that one.
Lastly, can someone file a workers' comp claim with a labor union if they were responsible for a claim?
I don't quite understand that question. If you got injured on the job, yes, you can file a workers' comp claim. I'm not sure exactly why you're bringing a labor union into this. Just not. I know that sometimes you go to the union hall, you get the assignment, you go to that place. Just file the claim. We will determine who the appropriate payer is. So, overarching message here, you got hurt at work, file a claim, let us sort it out.
All right. Thank you, Joe. That is all the questions we have. So we are going to go ahead and wrap up. But before we do, I want to thank you all for joining us today. Thank you, Joe, as always, for taking the time to give the presentation and answer your questions. Just as a reminder, this webinar series is offered monthly. So make sure you visit the webinar page on our website to see when our next webinar for Workers' Comp 101 is, and you can register for that if you need a refresher at any point, or if you have any colleagues who couldn't join today's webinar. You can also find a list of webinar dates for this series and a variety of other topics that we touched on. We have our Advocate for Business webinar series, our COVID-19 webinar series. Also, we have some paid family leave webinars that I saw a couple people beforehand had asked about questions about paid family leave and FMLA. We have some webinars coming up for paid family leave too that you can sign up for. And just go to our website to see more information about that. You can also sign up to receive workers' compensation news, including information on future webinars, straight to your inbox.
Adam,
Yes.
before Tony goes, Tony, I hope you didn't leave. There are 51 jurisdictions because the District of Columbia has its own comp too.
Good old Washington, D.C.
Exactly.
All right. So as I was saying, you can sign up to receive emails from us if you go to wcb.ny.gov, scroll down to the bottom of the page and select Get WCB Notifications. You choose the topics you would like to subscribe to. We also distribute information via social media, so make sure you're following the board on Facebook, Twitter, and Instagram. And again, that YouTube page is a wonderful resource for any recorded webinars we've done in the past. And with that, we would again like to thank you all for joining us.